I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The Department of Justice has just filed its reply brief to the 11th Circuit Court of Appeals in the expedited appeal regarding Judge Aileen Cannon's assertion of equitable jurisdiction following the Department of Justice executing a valid and lawful search warrant at Mar-A-Lago on August 8th. You'll recall a few weeks after the search warrant was executed and the Department of Justice got the thousands of records in connection with the search warrant that Donald Trump stole, including top secret sensitive compartmented records, our nation's highest secrets that Donald Trump stole. A few weeks later, Trump filed this motion for judicial oversight in the Southern District of Florida. The cases are randomly assigned, and it was assigned to Judge Aileen Cannon, who was a judge that Trump had appointed during the Trump presidency, and Judge Aileen Cannon has completely ignored the law. She found that she could assert equitable jurisdiction when there was no law to support that, and started this whole process whereby a special master was appointed, Judge Raymond Deary. And currently where things stand, approximately 11,000 or so documents are still part of that special master process. 100 classified records, which comprised all of the remaining top secret classified records that were obtained by the Department of Justice during the August 8th search warrant. Those records were compelled to be returned to the Department of Justice after the DOJ filed an emergency motion for partial stay with the 11th Circuit, and the 11th Circuit there found that Judge Aileen Cannon didn't have equitable jurisdiction regarding those records. So now we are dealing with the overall appeal to Judge Aileen Cannon's assertion of equitable jurisdiction, which she ruled on September 5th. That's what's currently pending before the 11th Circuit on an expedited basis. The Court of Appeals granted this expedited appeal process, and the Department of Justice filed their opening brief. Trump filed an opposition last week, and this week the reply brief was filed by the Department of Justice responding to Trump's frivolous arguments. And as I said, when Trump filed his opposition brief asserting these frivolous arguments, I explained that the Department of Justice was going to file on November 17th. That's when the reply brief was due. A very surgical motion reply dismantling Trump's arguments. So now everything is fully briefed before the 11th Circuit Court of Appeals. Earlier in the week, the 11th Circuit Court of Appeals set oral argument on November 22nd. That'll take place in Georgia. And so what I expect that will happen is on November 22nd, Trump's lawyers are going to be utterly embarrassed during oral argument because their arguments are completely frivolous. The 11th Circuit has already ruled that Judge Cannon shouldn't have had equitable jurisdiction regarding the 100 classified records, and the same arguments why she shouldn't have asserted jurisdiction regarding those documents also applies to the 11,000 other documents that Donald Trump stole, which are part of the special master process. So I have a great degree of confidence that the 11th Circuit is going to rule that Cannon should never have assumed jurisdiction over the case. Cannon's going to be removed from the case. The whole special master process is going to end. I don't think that's going to take place on November 22nd because usually the ruling doesn't happen on the date of oral argument, but I've always been predicting, and if you've been following the MeidasTouch Network, you know I've been predicting that by late November, early December, we will get a ruling from the 11th Circuit finding that Judge Aileen Cannon should never have asserted equitable jurisdiction in the first place. And you can watch the video that I did on Trump's opposition brief that he had filed last week to the 11th Circuit Court of Appeals, but he raised for the first time this bizarre and completely frivolous new argument, and he really focused for the first time on the concept that the records were personal records and not presidential records under the Presidential Records Act, which was not anything he had even really argued before. He hadn't argued that with Judge Aileen Cannon. So he's raising this concept for the first time now in this opposition brief filed with the 11th Circuit Court of Appeals. And his argument was that when he took the records from the White House after he left the office, by packing them, that automatically converted the government records, the presidential records, into personal records because he shipped them to Mar-a-Lago, and that converted presidential records into personal records. That was his main argument in the opposition brief to the 11th Circuit. And before, his argument about why a special master should be involved in the process at all and why Aileen Cannon should assert equitable jurisdiction had nothing to do with the records being personal records. You'll recall Trump's argument was that he claimed he should still be able to assert executive privilege, even though he was not the president, and he's not the president, that he can assert executive privilege over these records. But now he's focused on them being personal records. Trump also argued in his opposition the same thing he argued before when it came to the classified records that he lost. He argued that the 11th Circuit Court of Appeal doesn't have jurisdiction over the special master order, and Trump tried to act like the order by Judge Aileen Cannon on September 5 that relates to the special master is somehow different than the injunction stopping the Department of Justice from accessing the records, even though they are inextricably intertwined. The Justice Department is prevented from accessing these records while they remain with the special master. But Trump argued the special master process alone is not subject to an appeal, which the 11th Circuit previously rejected as complete nonsense. And in their reply brief filed earlier today, the Department of Justice just laid it out and pointed it out that that's complete nonsense and made the same arguments that prevailed when they got their 100 classified records back. So let me just read for you what the reply brief starts off. I mean, it starts off super strong. And the reply brief begins and says the following. It goes, "This proceeding should come to an end." That's how it starts. "This proceeding should come to an end. After the government executed a judicially authorized search, plaintiff initiated litigation purportedly to protect interests in asserting executive and attorney-client privilege over records the government had recovered. But plaintiff failed to meet this court's established test governing the exercise of equitable jurisdiction. Further, plaintiff's executive and attorney-client privilege claims provided no basis for the extraordinary injunction and special master review ordered by the district court." And then the briefing goes on to say that Trump has now completely made a different argument, not about executive privilege and not about attorney-client privilege, but instead that these records are personal records. And what the Department of Justice argues is, first off, that's an absurd and completely without merit argument. You can't convert government records and presidential records into personal records by stealing them and simply shipping them to the weird resort home that you live on. But what the Department of Justice says, well, if that actually is your argument, then there was no need for this whole process to begin with, because the whole process was based on your claim of executive privilege and attorney-client privilege. And if the records were just personal records, then those are obviously documents that the Department of Justice, through a valid search warrant being executed, can obtain. So you just essentially stipulated to the fact that the Department of Justice should have their records back. So that's what the Department of Justice argued. And the Department of Justice argued, as it did in its previous brief that it prevailed on when it got the 100 classified records back, that under the case law in the 11th Circuit Court of Appeals for asserting equitable jurisdiction, a district court can only do that in the most rare of circumstances. There has to be an extraordinary finding that the government engaged in a callous disregard for the rights of the individual they are investigating. Even Judge Aileen Cannon didn't find a callous disregard for the rights of Donald Trump. Why? Because a magistrate judge, Judge Reinhart, on August 5th, found probable cause and signed the search warrant that was then executed by the Department of Justice on August 8th. So what the 11th Circuit Court of Appeals previously held and what the Department of Justice argues here, The callous disregard standard is a threshold inquiry. After you find that there is no callous disregard, you can assert equitable jurisdiction. But then if you go to the other factors, irreparable harm caused to the person being investigated, the need for the person to get the documents back who's being investigated, the 11th Circuit then analyzed those. The 11th Circuit previously said, look, we don't even have to analyze these factors because you should never have asserted equitable jurisdiction when you didn't find callous disregard. But how could Trump have suffered irreparable harm and need the documents back? They're not his. He stole the records, so he can't claim that he needs records and will be caused harm by taking records that belong to the executive branch. And finally, what the Department of Justice argues here, again, is that of course the 11th Circuit has jurisdiction. The 11th Circuit has jurisdiction on what's called pendant jurisdiction, where the orders are inextricably intertwined. Here, the injunction, the stopping of the Department of Justice from getting their remaining 11,000 documents back is intertwined with the special master order. The 11th Circuit Court of Appeals has pendant jurisdiction. The 11th Circuit Court of Appeals has jurisdiction over interlocutory orders, and an injunction is a type of interlocutory order that the 11th Circuit has jurisdiction over, so they should be able to hear it there. And then there's also a concept in the law called a collateral order that the 11th Circuit can have jurisdiction over, which is basically like the order by Judge Aileen Cannon, in essence, has the effect of being a final order because it would prejudice the rights of the Department of Justice based on the order, in the sense that the Justice Department's not getting records back that they need for the national security interests. So in essence, Aileen Cannon's order kind of functions like a final judgment, even though it isn't necessarily a final judgment. That's basically what a collateral order is, and therefore the 11th Circuit has jurisdiction over it. So a very surgical, smart, meticulous brief, again, pointing out that Trump's claim that these records are personal is absurd. Trump also cites this Judicial Watch case, which he calls the Clinton Socks case, which the Department of Justice says that has nothing to do with this at all. In that case, that guy Finton, who runs that group Judicial Watch, filed a lawsuit in 2012 against the National Archives to compel them to have Clinton turn over audio recordings that were part of Clinton's autobiography. And there, the National Archives had actually made a finding previously that those audio recordings are personal records because therefore his personal autobiography. It wasn't stealing thousands of government records like Donald Trump did. And what the National Archives, what the Judicial Watch case also said is that you can't just claim things as personal records just because you want to. Like there's a definition in the statute for what's a government record and what's a personal record, and you can't just make it up and violate the law. Like that's not what the case stands for at all. And all the case stands for is the proposition that a private citizen can't sue the National Archives to compel the National Archives in the year 2012 to then compel Bill Clinton to turn over audio recordings, which the National Archives agree are personal. So that case has nothing to do with any of this, is, what the Department of Justice points out here as well. But very surgical, meticulous brief filed by the Department of Justice. The next step is we'll have oral argument on November 22nd. Again, I think it's going to be a very bad day in court for Trump and his lawyers. And then shortly thereafter, I think we'll get the final order that Judge Aileen Cannon will be overruled, and this whole special master process will come to a conclusion. As the Department of Justice says in a brief, this whole process needs to come to an end. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers thanks to your support. It's free to subscribe, so please hit the subscribe button. Also, consider becoming a patron of MeidasTouch by going to patreon.com/MeidasTouch. Check it out, patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's lots of exclusive content there that you could only get on Patreon, but most importantly, help grow this independent media platform. We are not funded by any outside investors, none of the millionaire billionaires that fund the both sides media and the pro-fascist media, none of that. So we rely 100% on you. Wherever you are in the world, you can contribute. Let's grow this community together. Patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.